All right. Well, hello, everyone. Uh, this is the first of the video recording lectures that we'll have for this summer session. I really enjoyed the first live Zoom session with all of you, getting a good feel for who I have in the seminar. Hopefully you got a little bit of insight about me and the way I approach our courses. I like to have a lot of discussion, a lot of questions, a lot of feedback from all of you. So we'll continue to have that type of engagement and discussion. We will obviously track the readings and the key principles, but I also want us to really delve into the issues and look at issues from different sides and be very creative in coming up with solutions. And I think that's really key to the learning process, is really thinking through what we're reading and being very critical, as well as kind of talking it out and kind of learning that way. So this recording video will be another aspect of the class this summer. And what I hope to do in these video lectures is to provide kind of an overview, a little bit of a roadmap about the readings, and not so much give you detailed point-by-point analysis, overview, or review of the readings. I think you can do that on your own. What I want to do is give a little bit of direction and context that will help you understand the readings, maybe organize the key principles a little bit differently than the way you read them or the way that they're structured in the readings themselves or in the videos that we have as well. So we'll see how it goes going forward. But for today, what I want to do is really talk about constitutional law and constitutional law structure, the key principles and fundamentals that you should know as you go forward in developing your proposals and really understanding policy proposals, why they're drafted a certain way and why they're not drafted other ways. Constitutional law is very dense and can be very complicated. Traditional law school is a one-year course, and we're going to condense that into 2, maybe 3 lectures and some readings. So it'll be quite abbreviated, but I think you can pick up some of the key principles that you'll need as you go forward. So let's go ahead and kind of jump in. We talked a little bit about this on Monday, but let me give just a tad more overview because it is important. Where are our laws coming from? That's the first thing that we have to understand when we are looking at policy proposals or going to discuss or propose certain policy changes to decision makers. Who are we presenting these changes to? And who has the authority to act? And then we'll get into the source of their authority and the limits on their authority in just a second. But really, these are kind of fundamental reminders that we have an executive branch. We're speaking just at the federal level. The executive branch, which is the president and all of the federal agencies, obviously the various departments. So that's one branch, and then obviously the legislative branch, which we had discussion about the House of Representatives and the number of members of Congress, and of course the interesting approach to the terms, because we talk about Congress as a whole, encompassing both the House of Representatives and the U.S. Senate, and yet we call individual members of the House of Representatives Congress members. So keep that in mind. When you hear a Congress member, that is actually a member of the House of Representatives. While U.S. Senator is just that, is a U.S. Senator. And yet when we talk about the branch as a whole, we talk about it as Congress. So just keep that in mind, especially when you're watching, either listening to podcasts or reading articles online or watching various news outlets. When they talk about Congress, keep an ear out for whether they're talking about the House of Representatives, U.S. Senate, or both. And so I get calls frequently from friends and family members say, hey, did you know Congress passed X and Y? And I say, well, that was actually just the Senate, or that was just the House of Representatives. It still has to go through the other house or the other branch, or yes, the other house at the federal level. So keep that in mind. The other key branch is the Supreme Court or the judicial branch. And there's not a lot of discussion about this in our readings, but it is a key component in shaping the laws in this country, and of course at the state level and in the state. And the role of the courts is obviously to take current law and to interpret it and to determine whether or not there are violations of law. And I think in particular for us, whether there are constitutional violations as we look into policy proposals. But there's a lot more to that will be relevant to what we're doing. And we'll go into a couple of examples today on the role of the Supreme Court and role of the judiciary and the judicial branch. So you won't be necessarily become experts in the legal field, but I think you will have additional knowledge and especially working knowledge about how to approach some of these policy issues and always being mindful of court decisions. I think that is one area of law, even in the work that I do as a lobbyist and working with legislators and others, there oftentimes is a gap in reviewing some court decisions that could impact the policies that we are debating or could limit our ability to move forward on in certain ways. So that's actually really, really key for us to take a look at. And as we know, there's been a lot of discussion about the Supreme Court impact on some major issues, Roe v. Wade, obviously, most recently, which I'll delve into just a little bit. So at the state level, state and local level, just a refresher, and we talked about this on Monday, the California State Legislature is bicameral, two houses, this California State Senate, the California State Assembly. I know all of you now have it ingrained into your minds how many state senators there are, 40, and how many state assembly members, 80. You will know that forever. So we will keep that. And of course, there are the County Board of Supervisors and the respective departments structured much like the federal level under the president, where the departments and agencies. And of course, there's the city council, with mayors and departments. I should also mention, I neglected to include in here, that there's the executive branch, of course, at the state level, and that is the governor and the department and agencies under his authority, and also the state judiciary, or the state Supreme Court that impacts. So I don't have that on the slide, but we should also keep that in mind. So federal, state, local, and local county board of supervisors and city councils. Typically, the county board of supervisors authority, it mixes with the local, with the city council authority. San Francisco is unique because it's the city and county of San Francisco. You may hear that phrase, or for those of you, I think at least one of you lives in San Francisco and worked in San Francisco, you hear that phrase quite often, the city and county of San Francisco, because it's an integrated local political body in San Francisco. But most areas have separate. For example, in Los Angeles, there's the city of Los Angeles, which is within the actual county of Los Angeles. County is actually much broader and encompasses a number of cities. But the County Board of Supervisors has a number of executive authorities that the city council does not, and vice versa. The city council has certain authorities that they do not. For example, in Los Angeles, the LA County Board of Supervisors oversees the county jail and the juvenile detention centers. And there is a lot of debate. We may talk about this later this year about actually shutting down the juvenile detention centers in Los Angeles County. And that debate is raging at the County Board of Supervisor level. And there's a lot of discussion about that now. I just had a conversation with someone down in Los Angeles about this, that they are making some budget decisions and some hiring freezes that could pave the way for shutting down juvenile detention in Los Angeles. So let's keep in mind that each level of governance can truly impact criminal justice reform and also public health. A lot of the public health programs are at the local level, in particular the county level. And some of you may have experienced that in your work here in Northern California or in the area. So just keep in mind when we're talking about policy decisions and your policy proposals, who are you targeting? Are you asking the state Senate, state assembly? Are you asking the governor? Are you asking the county board of supervisors? Or are you asking the city council or mayor? So that's really critical to identify. It's fundamental, oftentimes is overlooked. We just talk about decision makers, but you really have to identify that because you might draft your proposal slightly differently depending on which government entity you are targeting for the change. So keep that in mind. All right, so for constitutional analysis, and the readings and the videos that you watched for this class talk about this, is you have to look at it through a balance of government power, limits on government power, and also the protection of individual rights, which is, in fact, one limit on government power. So how do we ensure that the government is acting within its power and legitimate power and the authority which it has? How do we ensure that there are proper limits on government authority? And how do we determine what the limits on government authority and power should be? And a lot of that will be rooted in the types of protections of individual rights that are impacted by the proposed government action or the government power that's being exercised. So when you're coming up with your own policy proposal and you want to require whatever action it is, the question comes up, okay, well, we'll go through the steps, but you have to look at all the sides. You can't just look at what you want to do. You have to ensure that you understand where the power is coming from, what the limits are, and any individual rights or protections that may be impacted by that. And we'll get into specific examples in just a second. Okay, so let's start here. The next step, let's go here. Once you have identified the level of government that you're trying to impact, the next step is to identify where does the authority come from for this level of government to act. And if you're talking at the federal level, the state level, or the local level, you have to be very clear. And the reason for this is then you can be very confident that this level of government does in fact have the authority to act on your particular issue. So once you identify where that authority comes from, it will help you identify what the proper maybe limits are just from the authority itself, or to how expansive you can be as far as what you want to do. Also keep in mind another issue that was touched upon slightly in the readings and the video is the issue of preemption. Right? Is this, in particular, when we're talking about the state or local government taking action, is that entity preempted from acting on an issue? And this can happen in a number of ways. The federal government might have the authority, and states and local governments do not have that authority. I know that came up a lot in our reading and also in the video. So that is something to always kind of keep in the back of your mind. Is the state or local government preempted from acting? I can tell you, as a lobbyist, I deal with this quite a bit. These issues come up all the time, and typically I'm advocating on behalf, for example, on consumer protection issues. This happens very frequently, where we're pushing for some consumer protection bill, and the lobbyists for the business interest often argue, oh, you're preempted. Only the federal government can take action in this space, and the state government cannot. And so we have to identify what the state authority is. We have to look at oftentimes court decisions to identify whether or not the local government or rather the state government has been preempted from acting in particular areas. I'll think of an example in just a second, hopefully if I can get back to this. But this is really, really something that oftentimes doesn't get discussed very often, but you will have to consider it. Can't think of an issue top of my head right now on preemption, but I will get there in just a minute. Okay, so let's go on to the next issue. All right, so let's talk about Section 8 of Article 1 of the Constitution, and there are a number of enumerated powers of the federal government, and that was in your readings and I believe in the video. And I won't go over all of them right now, but what I do want to focus on are two key enumerated powers of the federal government, and that is power to tax and the power of interstate commerce. This is really where the bulk of authority comes from, and a lot of the policies that are adopted in this country come from one of these two enumerated powers. There are many others, but these are the ones I want to focus on for today. And I want to do a little bit of a deeper dive into interstate commerce. And some of you who may not be familiar with this term, it's essentially, the federal government has the right to act on any issue that involves crossing over state lines. So if it is, for example, transportation is huge, obviously, the federal government level. Clearly, you're talking about highways and freeways that go across state lines. That is one very clear and kind of basic concept of interstate commerce, right? Oh, it's going across state lines. The other thing that's really interesting and kind of goes to preemption is the federal government has authority on, let's say, in telecommunications. And when we're talking about calls that might cross over state lines, phone calls that come state lines, that is something that oftentimes the federal government only has authority. I'm getting a little bit outside of interstate commerce, but just to understand the concept of thinking, is there something about interstate commerce that allows the federal government to take action? And interstate commerce clause is actually very critical in the history of civil rights in the United States. And some of you may know that, some of you may not. But let me talk about this. And just to give you an example of how the source of authority for the federal government can, how we take these enumerated powers and then how they've evolved over the years to be utilized in a variety of ways. So in 1964, Congress passed, and notice I said Congress, so we're talking about probably the U.S. Senate and the House of Representatives, passed the 1964 Civil Rights Act to prevent discrimination in hotels and restaurants. So just use that example. There are many other components of the Civil Rights Act and subsequent acts as well dealing with civil rights. Question is, how did the Congress have this power to act? Why is it that the federal government could take action dealing with hotels and restaurants? Is there something in the enumerated powers that talk about hotels or that talk about where you eat? Of course not. There's nothing. But what there is a long-standing determination, as I said, is that anything that crosses over state lines, that in and of itself could be the anchor in establishing interstate commerce clause and the authority for federal government to act. And actually many components of civil rights laws were in fact derived from the interstate commerce clause. And so in passing the 1964 Civil Rights Act and in some of the legal challenges over whether or not Congress had the authority to act, there was reliance on cases that go far back. But let's just talk about, let's talk about this case first, in 64, the Klotzenbach versus McClung. And as you can see from the quote that I have posted here, that there was, the quote specifically from the case, an impressive array of testimony that discrimination in restaurants had a direct and highly restrictive effect upon interstate travel. And food was also delivered across state lines. So these were two ways in which it was established that restaurants, as one example, did have a nexus to interstate commerce. Sometimes the produce and other items that are used in restaurants would have to cross state lines. And also folks who are traveling around the country and stop at restaurants on their way to different places. Obviously, keep in mind back then, there was probably a greater reliance on driving across country and going different places than maybe today. But it's still, that's what happens on our federally funded highways that go across state lines. It's really key that Congress argued and the lawyers argued in favor of federal authority to act, that this does in fact derive from interstate commerce, is related to interstate commerce in that regard. So because of that, Congress was able to pass the 1964 Civil Rights Act, take other actions dealing with civil rights, and withstand legal challenges. Because keep in mind, the role of the judicial branch in many ways is to ensure, and keep this in mind, to ensure that the laws that have been passed are in fact constitutional, that they do not violate key constitutional principles. And so that could be whether or not there's actual authority for the federal government to act. It could be a number of other things. So that is kind of the check we have on legislation. Okay, so we're going to move forward on that. One of the other questions is, what are the requirements for this level of government to act? What are the limits and or tests for the exercise of this power? So what do I mean by this? Well, for anyone who's gone to law school, I'll share this story. So if any of you end up going to law school, or if you have friends or family that went to law school, we learned something on day one of law school, and we are told that we can answer almost every question. This is my experience. My law professor shared with me on day one, shared with the class on day one, that the answer to most questions was already known. And it was a little bit puzzling to us. I said, well, what does the professor mean by this? The professor said, I can tell you the answer to most questions in law school and in most legal settings is the following: it depends. And we said, well, what do you mean depends? Well, for our purposes, is this in fact constitutional exercise of power? Well, it depends. It depends on the facts. And it depends on the facts of the case. It depends on key facts. And so I share that story to highlight that as you're looking at these constitutional issues, don't just think that there's a cookie cutter application of, okay, this rule always applies. And so if it applies in this situation for this policy proposal, it must apply in this alternative policy proposal. That's not necessarily true. It is based on the facts. And so, for example, on the hotels and restaurants, the Interstate Commerce Authority was it was determined that that was legitimate power because of the traffic, literally the traffic that goes to restaurants and hotels can be across state lines. But if we were talking about some other type of business, and in fact that was not impacted or did not have a nexus to interstate commerce, then in fact that would not, the Congress would not have the authority. So if someone asks, oh, well, so if Congress has authority to act on interstate commerce, they can act on anything. Well, no, not necessarily. It depends on the facts. It depends on the facts of that particular case. So keep that in mind. And you have to look at what is being regulated and what factors or rights are being impacted. And so for the example of the restaurant or hotel, it was a type of business that did have a nexus to interstate commerce. So that was what was being regulated. And what factors or rights were being impacted. In particular, was there a right in the situation or in the context of hotels and restaurants? Did the owner of the business have a right to essentially discriminate and prohibit certain individuals from frequenting the business, right? From coming into their business and for serving them food or for allowing them to stay at the hotel. So when you look on balance, that did not have the argument that there was some sort of right to determine who can stay at their hotel or who can dine at their restaurant. That was not on the scale of things. That was not a highly regarded legal argument. There's not a real constitutional right to discriminate in that regard. As you know, though, again, depending on facts, there's been a lot of debate in recent years about businesses who do not want to serve either LGBTQ individuals or do not want to provide certain services for LGBTQ marriages or marriage ceremonies. And that comes up for a different reason. Again, if you look at the facts, it's a different balancing. It's because of primarily, oftentimes, religious exercise of the religious rights. And so that is a different balancing because there is a right to religious freedom in the United States. So that balancing is slightly different than the right for an individual that is who runs a restaurant or hotel to prevent a person of color from coming to that business. It's not derived from some sort of constitutional protection, civil liberty. That is simply derived from a business decision or from a personal ideology, as opposed to being derived from a religious ideology where there is constitutional protection. So the facts always impact the analysis. So you always have to identify what are the key facts here that could change the balancing between the right to regulate and the right to exercise of certain individual rights or the protections for particular individuals. Okay. All right. And I just was talking about that. So for our readings and for the video, a lot of discussion and reference was made to the vaccines and quarantine and isolation. And that obviously is a different type of individual right. And we'll get more into that maybe during our live lecture next week. But keep that in mind. And there's a lot of discussion about the individual rights that are impacted there. So again, I'm just trying to give you a way to organize this information so you'll be able to kind of really maneuver and navigate the constitutional issues much easier. This is a question that does not come up a lot, and in analysis and legal analysis or power analysis, or I'm sorry, policy analysis. And I think it's very critical, not just because I'm a lawyer, but because of the work that I do. It's always critical to look at legal doctrine and legal cases. And it's one thing you'll be surprised that as I do this work in Sacramento and I do lobbying, that a lot of individuals and a lot of lobbyists never look at court decisions, and they never look at kind of the history of court decisions that impact certain policies and why policies are drafted a certain way, or why when a policy was drafted a certain way years prior, that a court's weighed in and said, no, you can't draft it that way, or they interpret it a certain way. It's always critical because our judicial branch and the court decisions that are being made really transform our laws into being much more fluid than we may see, and than we may realize, right? You may look at the letters, the black letter of the law, and look what the statute says, but then you also have to look at the court decisions that have interpreted the words of that particular statute, or have weighed in and said, well, there's a piece of this that is unconstitutional. There's a piece of this statute that would be unconstitutional under this fact pattern, under this factual scenario. So it's really critical that when you're putting your policy proposal together, if you can, do a little bit of legal research, find some cases that could be impactful, and I'd be happy to help you with that. The other thing that's really, really critical to keep in mind is the basic concept of stare decisis. And that is essentially let the decision stand, right? That's what it means. And so we have court decisions from decades, centuries ago that were made here in the United States. And the way our legal system is set up is that when that decision is made, there is essentially an operating presumption that that decision was correct. And because of that, there has to be a consistency in subsequent decisions. So if there is a decision, Hernandez versus Jones on whatever civil rights issue from 1899, and in the U.S. Supreme Court, it was a unanimous decision, let's say, then when the same issue comes up in 1999, there is going to be essentially a kind of a legal doctrine that says, well, we kind of have to leave in place the decision that was made before. There has to be very powerful and convincing legal arguments to overturn a decision that was made previously, and a court decision that was made previously. And so otherwise, and the reason is because this concept of stare decisis, that there is a presumption, essentially a presumption, operational presumption, that you have to let the decision stand. And so you can build on court decisions, but you cannot undo the court decisions. Now, that's not 100%. Court decisions are changed all the time when the makeup of the either state Supreme Court or U.S. Supreme Court changes. Then oftentimes they move away from decisions that were made earlier, and they say, well, those were wrong because of X and Y. And oftentimes they have to be very creative legally to do that. And we see that clearly over time in California, when there was the Rose Bird Court, and before some of the California State Supreme Court justices were voted out of office, one of the rare times. Then a lot of court decisions after that, it was a challenge for the more conservative justices that were trying to undo the decisions from the progressive era. So, and then vice versa, the progressive court, for example, at the federal level, now with a more conservative court and conservative justices in the U.S. Supreme Court, they have to come up with creative legal arguments to depart from prior decisions. Okay, so that's key to know, that if you find court decision from years ago, just know that there's kind of a presumption that should stay in place and guide any future decisions. So let me give you an example. One of the basis for the constitutional basis for Roe v. Wade was a court decision from May 25th, 1981, the Union Pacific Railway decision versus Botsford. And that was actually, again, it kind of goes back to stare decisis. It goes back to the concept of let's look at court decisions that came before to explain kind of what rights are involved. And that's what the Supreme Court justices have to do. They can't just walk in and bring in their own personal views. They really have to be students of and experts in court decisions that were made prior, and the ability to go back and look at court decisions and then bring those principles over while preserving the concept of stare decisis for the most part. Not always, but for the most part. So as you can see in this court decision, this reference, and I'm trying to remember the exact fact pattern in this railway decision. I can't remember if it had something to do with passengers on the train. I'm blanking it at this moment, but what's key is that the argument that was made and the legal principles that were articulated were then utilized later in Roe v. Wade. As you can see that that there's no right more sacred or more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others. I'm trying to remember now, but I think they were trying to, I'll get back to that. I'll bring it up during our live lecture. It was actually a very interesting case. But that was, in Roe v. Wade, the U.S. Supreme Court, the justices went back and found some of these key decisions and these key legal principles to bring it forward, because there is no right to choice in the Constitution, so it just had to be built on and derived from prior court decisions. And of course, we know what's been going on as of late in the U.S. Supreme Court when it comes to the right to choose. So that's a longer discussion, but certainly, as you can see, kind of the legal maneuverings that the conservative justices have been making in order to try to undo Roe v. Wade. All right, so let's go forward. All right, so a couple of things. Hopefully, it won't take too much longer here. Now, when there's an individual right or individual liberty that is being infringed upon or being limited, that is, I'm going to skip ahead real quick. That changes the way we look at constitutional analysis. Okay, now I'm going to explain this graphic, which I borrowed from someone, in just a second. But here's what you have to understand. When there is a law and there is a constitutional analysis of that law, there are, and I'm going to oversimplify just a bit, but when you're trying to determine the constitutionality of a particular law under a certain set of facts, you have to determine what type of analysis is conducted. And what do I mean by that? I mean, there are some laws where the limit on government is lower. It's much easier for the government to take certain types of actions, meaning that there's less constitutional impediment to taking that action. And that is, in this graphic, is what we call rational basis review. I'll get there in just a second. Then there are certain facts and certain liberties and rights or protections, when they're invoked in a particular policy, there may be intermediate scrutiny, meaning that the government only has to justify their actions at a higher level than under rational basis review, but not the highest level. So it's kind of it's intermediate, it's in the middle. Okay, and remember, these tests and these level of tests, 3 levels of tests, all have to do with what level of test does the government have to show to justify its actions. Okay, so there's rational basis review, intermediate scrutiny, and then the highest level, meaning is the most difficult for the government to prove that its actions is in fact constitutional, is strict scrutiny. Okay, and so that is when it's the most difficult. Now, one of the examples that was used in, I believe, is a video, is when you are looking at, I think it was a public health policy. It may have been around access to food and access to certain like supermarkets, whatever it was. And the idea was, okay, well, why don't we put together a proposal or a policy that focuses in on providing more services in areas where there's a higher concentration of people of color, African Americans, let's just say, as an example, something like that. And so the policy itself is based on race. Now, that typically will trigger this strict scrutiny. And what did we say? This is the highest hurdle that the government has to overcome to show that it is in fact a constitutional act of government. And so adopting a policy that says in all African American communities, this is what's going to happen, that would require strict scrutiny, because again, that could be a policy that's good or bad for the community, but it is based on race. And so that is the most difficult. And you heard in the video that the alternative to that is to identify, why don't we identify a way to have the same outcome, meaning that we get, greater access to, fresh produce, for example, in certain communities, without focusing on race, and instead saying, why don't, let's focus the funding or focus the policy proposal in communities where is the highest rate of type 2 diabetes or the highest rate of heart disease, some other basis for concentrating efforts in particular communities, which does have an overlap with race, but the actual policy and the actual government action is not based on race. It is simply based on this kind of public health factor. And that, as you can see in this this graphic here, a law based on public health trends would not be something under strict scrutiny, would not be under intermediate scrutiny. It would likely be under rational basis, which means it is easier for the government to prove or to avoid any kind of constitutional violation going forward. So keep that in mind when you want to adopt a policy, if in fact you're trying to concentrate the policy on particular communities, people of color in particular, race or national origin, or if you're trying to restrict travel or the other kinds of fundamental rights that were talked about in the video and also identified here in this graphic, that if you're going to do that, it's going to be much harder to prove that the government action or the policy is in fact constitutional. It can be done, it's just much harder. And the video did talk about some of the specific tests and in more detail, and I could talk about that, probably on Monday. I'll talk about that as well. So, for example, here's what I just discussed here: is how do we craft policy to address disproportionate access to healthy foods, particularly neighborhoods? Race, question, national origin, economic status. And economic status would not be strict scrutiny. It would probably be intermediate scrutiny, maybe rational basis. But certainly public health identifiers would be, in fact, rational basis. So keep that in mind when you're putting together your policies. Okay. Let me switch just a little bit. And we talked about this already. By virtue of what authority does the state or local level of government have the authority to act? We talked about the authority of the federal government and the enumerated powers of the federal government. But also keep in mind that the state and or the local government, they also have to identify where that power comes from. The majority of the time in California or in other states, but in California in particular, the local governments derive their authority from the state government. Let me say that again. Local governments quite frequently derive their authority, or it's delegated from the state to the local government. And that's how that works out. But for that delegation, then the local government would not have the authority to act. And why is that important? Well, it's important for a lot of reasons. But in particular, it's important, let's say, in the criminal justice context. So one of the things I do is I lobby a lot on criminal justice reform. I'm passing bills at the state level, state legislature, to impact prosecutions. Let's say, for example, I'll give you an example. I have a bill right now going through the legislative process, and I will update you throughout the summer on this. And this changes and mandates specifically that prosecutors must provide particular evidence very early on in the felony prosecution process. So right now, what I mean by this, so right now, the law says that the prosecutor in a felony case has to provide certain evidence, but not until 30 days before trial. Okay, there's a lot of steps and a lot of time can pass between arrest and 30 days before trial. And can you imagine in a case that you know someone or you're representing someone, or I used to represent someone, and there's key evidence that could help change the entire trajectory of a case, but you don't get it until 30 days before trial. It's very problematic. And oftentimes the prosecutors may not provide it at all. But let's just say they follow the law and you don't get the evidence until 30 days before trial. That could be very, very problematic, especially when there's negotiations on settling a case or someone's sitting in custody for a long time and you don't have, as the person accused of the crime or their attorney, you don't have all of the information to really put together a proper defense. So that's problematic. So I have a bill this year, and I should say that that was put in place by a ballot measure during the Tough on Crime era. And so I have a bill this year that will undo that, at least pieces of that. It will say every prosecutor must provide very specific evidence early on in the process before what they call preliminary hearing. I'll talk more about that in another lecture. But essentially, it's the first time that someone goes before a judge and there's evidence actually presented to the judge. It's very early on in the process. It's after arraignment. It can be as early as 10 days after arrest, typically about 60 days after arrest. And so I'm passing a state bill to require a prosecutor. Now, some of you may know, you may not know, that prosecutors are not state employees, okay? DA offices are not state offices. They're not departments of the state of California. They are departments of county government, okay? LA has city attorney. That's different. But they also have DAs. So in almost every county, the DA handles felonies and misdemeanors. How does this local government have the authority to do that? Well, I'll tell you this, it's delegated from the state. Okay, from the state authority, the state has delegated these powers to the local government. So when you look at a charging document, if you look at someone who is charged with a crime, it is the state of California versus whomever. Okay, it is not the county of Los Angeles versus whomever. It is the state of California versus whoever. Okay, why? Now, I went through all of this. And why is this important? It's important for one key reason. Let's say I came up with this proposal about providing the evidence. And then for this class, I came up and said, hey, I want a proposal that provides evidence early in the process. DAs have to do X and have to do Y. Who am I gearing that policy proposal towards? If I didn't understand that the state delegates authority to the local government, I would think that, oh, it's an Alameda County DA, so I want to write my policy proposal to convince the Alameda County Board of Supervisors to require prosecutors to do X or Y. And that would be inaccurate. The Alameda County Board of Supervisors does not have that authority. The state has the authority that has been delegated to the county. As a result, I do my work at the state level to impact criminal prosecutions and to impact and change what prosecutors do at the local level. And anything dealing with criminal justice reform is dealt with at the state level. And that's why, because the state delegates the authority, the state can make those changes. Because if they did not delegate the authority, and it was authority that existed standalone at the local government level, then there would be some problems and challenges to actually exercising authority and trying to tell the local governments what to do. Okay, there are ways to do it, but for the most part, you can't do that. And so that is why criminal justice reform, for the most part, takes place at the state level. As I mentioned before, local jails, county juvenile detention centers, those entities are run by the County Board of Supervisors. State prisons are run by the state of California. So you would go to the state of California to fight over the funding, for example, San Quentin. That is a state prison. the Alameda County Jail is not run by the state of California. It is run by Alameda County Board of Supervisors. So if you want to change what happens there, you can go both ways. You can go to Alameda County Board of Supervisors, impacts their funding, or you can pass a law that could impact all local jails. Right, there are some limits to that, but for that type of part of the criminal justice system, you go to the state level. So hopefully this is not too much or too fast. But the bottom line is, understand local governments, if it's their standalone authority or if it is authority that is derived from the state. And that's important to identify where you would go, which decision makers you will go to for your policy change. Okay. All right. Well, that is the end of our lecture. Or my lecture for today, my first time doing this video recording. Hopefully it went well. Hopefully this helps guide you as you're putting your policy ideas together, and also as you are working through the readings and going through the video assignments. Give you a little bit better understanding and put it in a little bit different context and highlight a couple of other things. I think that will be helpful. So thank you, and I look forward to our next session on Monday. All right, take care.